Hello guys, welcome to Skill Legal Blog. Today I will discuss with you what are the subject matter of copyright protection. Friends, as mentioned earlier, copyright protection is available in various fields of intellectual creativity. Section 31 of the Copyright Act has provided categories of works in which copyright subsists. It reads as follows. Subject to the provisions of this section and the other provisions of this Act, copyright shall subsist throughout India in the following classes of works, that is to say, artistic works, cinematography, literary works, dramatic works, musical work, literary work, sound recording, and computer programs, etc. So now we see in detail the following above said eight classes of works. So the first one is artistic work. Artistic work means any painting, any sculpture, or any drawing, including maps, chart, and a plan, and engraving a photograph, whether or not such a work possesses artistic quality, or a work of architecture, and any other work of craftsmanship, any work which has artistic quality. This has been provided in section 2 subsection C of the Copyright Act 1957. So the main concept is painting. Painting is an artistic work. Even if it possesses no beautiful quality, what is sufficient to entitle it for a copyright is that it must be original. That is, the painting should be the creation of the painter and not mere a copy of another painting. A painting, in order to be copyrighted, must be on a surface. It is a tangible object and not only an idea. Only a painting and a tangible surface is entitled to the copyright protection. Next is photograph. A photograph is an artistic work entitled to copyright. A photograph must be original, that is, originally taken by the photographer, to be entitled to protection, and not to be original. Investments of some degree of skill and labor must be evident. A photograph of a public object, for example, a public building, when photographed in a particular manner by a particular individual, is a subject matter of copyright. And this does not prohibit another person from taking a photograph of the same object from same angle and claim an independent copyright. A photograph or a Xerox copy of a photograph itself cannot be subject matter of copyright, since there is no involvement of original skill and labor in making such copy. Second is cinematography. Any work of visual recording on the medium produced through a process from which a moving image may be produced is known as cinematography. It also includes sound recording accompanied with the visual images. It shall also be constituted as including any work produced by a process analogous to cinematography, including video films, includes any writing, computer programs, tables or compilations, including the computer database, such as cinematograph films means section 13b subsection b 13(1) subsection b incorporates cinematograph films as eligible for copyright protection. Cinematograph is a film which, by rapid projection through an apparatus called projector, produces the illusion of motion on a screen of many photographs taken successfully on a long film. The soundtrack associated with the film is also a part of the cinematograph film, and in the case of Balwinder Singh vs. Delhi administration and Tulsidas vs. Vasanta Kumar, it was held that the video films and television have been treated by cinematograph film within the meaning of section 13(1)b, and as such they are also eligible for copyright protection. Third main classes of work is literary work. Literary work includes any writings, computer programs, tables, and compilations, including the computer database. The expression literary work has been defined in section 2(o) of the Act as including computer programs, tables, and compilations, including computer database. Some examples of literary works in which copyright subsists are given hereunder, such as dissertation. The research thesis and dissertation prepared by a scholar involves labor and skill, and thus entitles for the copyright protection. In the case of Fateh Singh Mehta's case, the Rajasthan High Court granted interim injunction against use of material by guide from the PhD thesis of his student. Second is question papers. The person who sets the question papers invests labor, skill, and time on the preparation. He is the author of the question paper, and the copyright vests in him. Next is encyclopedia and dictionaries. Preparation of a dictionary on any subject involves considerable amount of labor, skill, and judgment, and the copyright will subsist in dictionary for arrangement, sequence, or idiom format which cannot be appropriated by another, or head notes of law report and digests, and translation and the abridgment of literary work. Now, what is the abridgment? Abridgment is the reproduction of an original work in a much more precise and concise way. A genuine abridgment of a literary work is an original work and a subject matter of a copyright. The above illustrations are merely illustrative and not exhaustive. Some more categories of works such as letters, lectures, code, words, catalogs, storybooks have been granted copyright on the ground that the work has involved labor, skill, and originality in preparation. Various preparation of syllabi, report of judicial proceedings, and single word have not been found eligible for copyright protection. Next work is musical work. Section 2p defines musical work as a work consisting of music and includes any graphical rotation of such work but does not include any words or any action intended to be sung, spoken, or performed with music. So, the next is the song. There is no copyright in a song. The words of the song create a copyright in the author of the song, and the music of the song is the copyright of the composer. But the song in itself has no copyright. In a case where a song is written and the music composed by the same man, he would own the copyright in the song. Next is old song with different music composition, which is known as remix. The remix songs, which are the very popular among the young generation, is within the definition of adaptation of a musical work. Such adaptation is not an infringement of the copyright of the original musical composition. Supreme Court, in a significant judgment, has held that the version recording, if done by a skillful and laborious arrangement of different music with due permission of the original owner of songs, it may claim protection of copyright. Fifth class of works is sound recording. In section 13, subsection 1, subsection C, as the same has been added by Amendment Act of 1994, the sound recording has also been made eligible for copyright protection. And according to section 2, subsection 20, sound recording means recording of sound from which the such sound may be produced regardless of medium on which such recording is made or the method by which the sound is produced. The right of sound recording is different from the subject matter recorded as they are the subjects of independent copyrights. The author of the sound recording is the producer, and the musical works and sound recordings embedding the music are considered separate subject matter for copyright. The copyright in the recording of music is separate from the copyright in the music. Copyright in the music vests in the composer, while the copyright in the music recorded vests on the producer of the sound recording. And where the song has not been written down and the composer, who is also the performer, records the song, two copyrights come into existence simultaneously, one for the music and one for the sound recording. Sixth class of works is computer software and programs. Article 10 of the TRIPS and Berne Convention of 1971 required copyright protection for computer programs, including software and issue relating to internet. As such, the Copyright Act was further amended in 1999 to include computer programs as part of literary works entitled for protection under Section 13(1)(a). Section 2(a) says literary work includes computer programs, tables, and compilations, including computer database. Computer program means a set of instructions expressed in words, codes, and scheme, or in any other form, including a machine-readable medium capable of causing a computer to perform a particular task or achieve a particular result. Computer software includes many items like the programmed manuals and papers, punch cards, and magnetic tapes or disks required for operation of a computer. Program manuals and papers and computer printouts may be considered as literary work, but the concept or idea of algorithms frequently used in computer programming is not capable of copyright protection. Punched cards, which contain certain information in particular notation, may be considered as literary works, and the programs devised for the working of computer is generally regarded as literary work. And the magnetic tapes and disks, including floppy disks which contain information recorded by the means of electronic impulses may be considered as database and accordingly literary work by definition. So friends, these are the mainly sixth kind of classes of work, and the next is seventh, work of architecture. A work of architecture according to section 2b means any building or structure having an artistic character or design or any model for such building or structure. It is eligible for copyright protection as artistic work. The work must have an artistic quality. A layout of a garden containing steps, walls, ponds, fountain, etc. can be considered a piece of architecture. According to provisions of section 13, subsection 5, copyright in a work of architecture does not extend to the process or the method of construction. However, the building or structure which constitute a work of architecture is built on the basis of plan which enjoy a separate copyright apart from the copyright in the building. So